Go ahead and call the meeting to order. This is the May 20th special call meeting of the City County Planning Commission. And I will ask Mr. Ramsey to please call the roll.
Yes, ma'am. Commissioner Balance, Commissioner Blackburn,
Yes, ma'am.
Commissioner Clark,
Yes.
Commissioner Gay, Commissioner Graham,
Yes, ma'am.
Commissioner Ritchie,
Yes, ma'am.
Commissioner Starks,
Yes, ma'am.
Commissioner Unseld,
Yes, ma'am.
Commissioner Vitale,
Yes, ma'am.
Commissioner Volkert,
Yes, ma'am.
Commissioner Warren,
Yes, ma'am.
Chair Runner.
Yes, ma'am. Commissioners, you've all had a chance to review the summary minutes of the May 6th meeting. Are there any corrections to those minutes? No corrections. I'd ask for a motion, please.
Motion that we approve.
Thank you, sir. We need a second.
Second.
Thank you, ma'am.
Commissioner Starks, Commissioner Starks.
Yes. Yes.
Thank you, sir. Commissioner Unseld,
Yes, ma'am.
Commissioner Vitale,
Abstain.
Commissioner Volkert,
Yes, ma'am.
Commissioner Warren,
Ma'am.
Commissioner Blackburn,
Yes, ma'am.
Commissioner Clark,
Yes.
Commissioner Graham,
Yes, ma'am.
Commissioner Ritchie,
Ma'am.
Chair Runner.
Yes, ma'am.
Ms. Runner, I request that you order the record include all statutory and regulatory provisions, the commission's entire file for each application on tonight's agenda, and the qualifications for each staff witness. Finally, I request that you administer the oath to each of those witnesses.
So ordered. Do you all swear to tell the truth before this commission?
Yes, ma'am.
Thank you all. The subdivision review that was in your packet, any questions on those, the approvals? No questions? Letters of credit and performance bonds, I don't believe we had any, nothing to add on those. Okay.
Nothing from there was some new ones, and an email, an updated agenda.
Okay, you got those. Okay, I didn't have a copy. I don't have that. Okay.
I didn't get that either.
You didn't
I
get
did
that?
not get that.
Do you need-
Ben, do you want me to go get those and we can read them?
I can go ahead and read it now.
Okay.
So the letters of credit and performance bonds, we have two items. Number one is to release the cash bond for construction on Blevins Farm in the amount of $275,140 and replace it with a letter of credit for Sidewalks in the amount of $79,300 from GVTP Developments LLC. So this would be a reduction and a replacement of a type of bond. The second item is to release the letter of credit for construction on McCoy Place, Phase 4, in the amount of $109,000 and replace it with a cash bond for Sidewalks in the amount of $10,000 from H&D Development LLC.
Thank you, sir. Any questions, commissioners? No questions? I'll ask for a motion, please.
So moved.
Thank you.
Second.
Thank you, ma'am.
Commissioner Vitale,
Yes, ma'am.
Commissioner Volkert,
Yes, ma'am.
Commissioner Warren,
Ma'am.
Commissioner Blackburn,
Yes, ma'am.
Good job, Mom.
Commissioner Clark,
Yes.
Commissioner Graham,
Yes, ma'am.
Commissioner Ritchie,
Ma'am.
Commissioner Starks,
Yes, ma'am.
Commissioner Unseld,
Yes, ma'am.
Chair Runner.
Yes, ma'am. That's fine.
I'm not as good at this as Jessica is. I'm sorry. I think that was my fault that you all didn't get that. I apologize.
No problem.
You're doing great.
I'm no Jessica, but I'm going to try.
No, I'm glad I've got them both in here with me. We do not have any unfinished business or new business, so we'll go ahead. And our first item tonight for public hearing is docket number 2021-10 DP VG Lanco LLC and others have filed an application to amend the general development plan, which are the development plan conditions on tracts of land containing approximately 58.863 acres located at 0, 30, 40, and 3200 Ken Bale Boulevard. These properties are zoned highway business with a general development plan. And we will hear the staff report from Ms. Herb.
Thank you, Chair Runner. Apparently, I did not share the right screen. Let me try this again. Ready? Can everyone see the screen okay with PowerPoint?
Yes, ma'am.
Yes.
All right, sorry for the delay. Okay. So we had a pre-application conference on March the 24th for the properties located along Ken Bale Boulevard, located at 0, 30, 40, and 3200 Ken Bale Boulevard. And the applicants have applied to amend the general development plan for roughly 58.86 acres in order to allow a gambling facility, establishments with more than 60% of dedicated seating at a bar, increase the permitted height for freestanding signs, and reduce the required landscape buffer along the western portion of the development. The current zoning for the properties is highway business. And you can see from the land use map that within the development, there are some properties that are already developed with commercial uses. There are some properties that remain agricultural in use with some vacant tracts also present within the development. The future land use designation for the properties is commercial, and the proposed development plan amendment does remain consistent with the future land use map. Looking at the site characteristics review on page 2 of your staff report, this was the preliminary development plan that was submitted with the development plan amendment. You'll see the properties that are already developed kind of on the bottom portion of the screen here. And the purpose of this application tonight, the main reason that this application was filed is regarding this tract here, kind of in the central portion on the top side of Ken Bale Boulevard as you're looking at the screen. And so that was kind of the reason for this request this evening, to allow a proposed facility, and we'll get more into that in just a second. With that, I'm going to just touch on a few items in the site design and compatibility review section. The first of that on page 3 being landscaping and screening. Landscaping and screening will follow the requirements for the highway business zone, including landscaping between incompatible uses and landscaping for vehicle use areas. The current binding elements require a 25 landscape buffer adjacent to properties zoned agriculture, RM4, and mobile home park. So if I go back to the zoning map here, you can see that there are 2 properties on the west side, one zoned agriculture, one RM4, and then at the top, mobile home park. So currently there is a 25-foot landscape buffer requirement adjacent to these properties. And part of the application before you this evening includes a reduction of that buffer along the western portion here adjacent to the Ag and RM4 properties from 25 feet to 15 feet. And looking at signage, the current binding elements require that freestanding sign be monument style and limited to 13 feet in height with 100 square feet of sign face area for each sign. The applicants are proposing to remove the restriction on height to allow freestanding signs up to 30 feet in height, which is the maximum height permitted in highway business by the zoning ordinance. Some properties, if located in a high-rise sign district identified by the zoning ordinance, are permitted to have an additional freestanding sign between 50 and 100 feet in height. However, none of the properties within the development are located in this space that allows that type of sign. Go back. The preliminary development plan as we move through the rest of the staff report here. Looking at the traffic impact study requirements on page 3, section 314 of the zoning outlines those requirements, and a traffic impact study was prepared and submitted with this application by QK4. This was specifically in reference to the lot on the west side of Ken Bale Boulevard, which would be this lot on the top side of Ken Bale Boulevard as you're looking at the exhibit. The following conclusions resulted from the study. First, that left turn lanes would need to be striped in the median of Ken Bale Boulevard, both proposed entrances. So if you look at the site plan here, you can see that there's one entrance proposed across from what would be the Sam's Club entrance on the other side, and then another entrance proposed on the north up here towards the top portion of the concept. Next, from the conclusions in the traffic impact study, no major impacts are seen with development traffic added to the network with the exception on the northbound left turn opposite the proposed south entrance. The movement to a level of from a level of service D to a level of service F in both future year scenarios with build traffic added to the network. And it is recommended that this intersection be compared to signal warrants within a month after opening the facility. Analysis shows that all movements at the intersection would operate at an acceptable level of service with signalization. So the applicants did agree in their development plan conditions to set forth the improvements that are outlined in the conclusion section that I just went through. Additionally, there was a revised traffic impact study that was submitted to staff on May 7th, and we forwarded the revised study to our transportation agencies. They had reviewed the original traffic impact study, and then so they had the opportunity to review the revised study, and we did not receive their comments back until after packets were mailed to the commission. And so we did receive additional correspondence on Monday from the Bowling Green Public Works Department and the Kentucky Transportation Cabinet. One item worth noting is that the Public Works Department for the City of Bowling Green has required an installation of a traffic signal at the proposed southern entrance across from the Sam's Club entrance. So that would be kind of in the central portion of the concept here where that's going to be required. That's not addressed in the development plan conditions, but I believe that the applicant's counsel is on the call, and I believe in speaking with Mr. Reynolds earlier this afternoon that they're agreeable to that requirement. With that, I'm going to move on to the development plan conditions. Again, this is an amendment, and so the changes are either shown for deletion with strike-through text, or if it's an addition, it's shown as underlined text. The first four items are really either housekeeping items or items that are already required by ordinance. So just because they're removed doesn't mean that those things won't necessarily be required, but it's just the fact that they're required by ordinance regardless of what the conditions say. So those are proposed to be removed and then replaced with three new conditions. The first, number one, which is kind of hard to see on the small screen here, but if you draw your attention to where the little hand on the screen is, and actually let me go back to one of the other maps here really quick so you can get a better frame of reference. So if you look at the aerial here, Wall Street comes in from the west, but it does not physically connect with the subject development here. There's a little tiny gap with another piece of property that is not involved in this development. And so it does not physically connect as of today. But what the applicants have agreed to in number one, new condition number one, is that the property essentially on the north side, or the west side of Ken Bale Boulevard would be developed in such a manner to facilitate a new connection to the existing Wall Street in the event that were connected with the property in the future. So they've agreed to provide a means of connection in the future if Wall Street were to be extended, and that's the number one. Number two, the applicants have also agreed to widen the sidewalk along the front portion of the property to at least 8 feet with final design and width of the path to be coordinated with and approved by staff to address some of the recommendations in the comprehensive plan regarding greenways and pedestrian connections. Number three looks at those traffic impact study requirements and those conclusions that we went through just a second ago. Again, they're agreeable to those improvements. Number four is 4, 5, and 6 mostly are not proposed to change. Number 4 addresses lighting. Number 5 looks at landscaping and interconnectivity between parking areas. Number 6 looks at building materials. The application before you this evening does add that little section at the end that states, provided, however, that decorative architectural metal panels shall be allowed so long as fasteners are not visible. Number 7 will remain the same and addresses landscaping and lighting. Number 8 deals with the reduction in that buffer that I had mentioned earlier. Again, that was in reference to the portion of the property adjacent to RM4 and Ag Zone property. So that'd be the top property line here on the concept. Again, reducing that buffer in that area to 15 feet. They have also included options to clear out underbrush and remove trees that are not in a healthy condition and to perform corrective pruning of existing trees within that 15-foot buffer. Number 9 and 10 will not change and address building height and buffering along the northern property boundary. So that'd be the right property line on the concept here. Moving on to page 6. Number 12 is that change regarding signage, increasing the permitted height for freestanding signs from 13 to 30 feet, which is the maximum, again, allowed in the highway business zone. The portion of number 12 proposed to be removed is a housekeeping item. The type of signage described in this section of the current binding element is not currently allowed under the zoning ordinance, so that is proposed to be removed. Number 13 will not change. 14 will stay the same, looks at maintenance of retention areas, and then 15, which addresses prohibited uses for the development. You'll see there in letter D, the applicants would like to now allow a tavern, restaurant, or other establishment with more than 60% of its seating being located at a freestanding or other type of bar. And then in number 6, the application proposed this evening would allow a gambling facility or operation other than charitable gaming, including but not limited to track or sports betting parlor, table games such as blackjack or poker, slot machines, video poker, blackjack, keno machines, or similar gambling devices, or a bingo hall, provided, however, that any facility may sell lottery tickets as an incidental part of its business. So those would all now be permitted uses under the application that's before you this evening. Jumping down to section 312.8 of the zoning ordinance, this section outlines the requirements to amend a general development plan, including development plan conditions. The applicant provide a justification statement, which is listed on page 7 and 8 for your reference. Then looking at our Focus 2030 category review, the staff evaluated 12 items. We found 5 of those items to be in compliance, 0 were out of compliance, and 7 of the items the planning determined for compliance. The first of that being LU 1.1.3, which looks at compatibility. Next, LU 2, which looks at quality of development and character preservation. Next, jumping down to LU 252, HN1 and HN 1.3, which address infill development, character of the area, and urban design. Next, ED1, which promotes diversification of the local economy. And last, ED 9.1, which encourages opportunities for tourist support facilities. Again, just to wrap up with a summary, the proposed amendment would allow a gambling facility, establishments with more than 60% of its seating being located at a freestanding or other type of bar. The application would increase the permitted height for freestanding signage to 30 feet and reduce the required landscape buffer width adjacent to the properties currently zoned agriculture and RM4. And then jumping up back to page 1 with our points to consider. Again, the proposed amendment does remain consistent with the future land use map and commercial category. Second, the proposed development complies with the majority of the site characteristics review and a majority of the review criteria for site design, with exceptions noted regarding landscaping and signage. And last, the Planning Commission should determine if the proposed development plan amendment is compatible with the surrounding area and if the applicants have addressed the findings required to amend the general development plan. That is all I have for the staff report, but I'm happy to answer any questions.
Thank you, Ms. Hurt. Commissioners, do you have any questions before we hear from the applicant?
Rachel, may I ask a couple of questions?
Yes, ma'am.
Okay, first of all, why are they trying to reduce the landscaping on that one side? Because that's still residential, is it not? And don't we want,
That's correct, Commissioner Clark. That may be a better question for the applicants. That they may want to provide more information as to why that buffer is proposed to be reduced. I believe there may be some information in that justification statement that they provided, I think on page 8. So they may want to speak more to that here in just a little bit.
okay. And then the other question is, this also has to do with Sam's and the farm place out there. Can they now change their signage and change their thing based on these conditions?
Yes, ma'am. So everything outlined in red, currently zoned highway business, is subject to this development plan amendment. So these changes are applicable to the entire development outlined in red on the screen.
Okay, so they can come in now and change all theirs, and they could even go, if this is passed, they could even go into gambling type facility also.
If that were to be approved this evening, that's correct. These conditions would apply to the entire development.
Okay, all right, then I have questions for the applicant. Okay, thanks, dear.
You're welcome.
Rachel, I have a question on page 6
Yes, sir.
on D and E that the proposed applicants want to make these changes. So the original landowner put these restrictions of any tavern, restaurant, no more than 60% seating, charitable, and number E, charitable gaming, track sports, whatever. Just out of curiosity, how long has that been a restriction on the deed of the land?
Commissioner Warren, the original zone change was in 2003. So those binding elements, or what we now call development plan conditions, have been in place since 2003.
Okay, by the current owners of this land.
It was with some of the current owners, I believe, were part of that application. But some of the properties have since been developed and are under different ownership. The property owners currently are listed on page 1, but at the time of the original application in 2003, the binding elements that you see before you propose to be amended are what were adopted.
Thank you.
You're welcome.
Rachel, I have a couple of questions, if I may. I've read the applicant's narrative regarding the landscape buffer. My question is more specific. From a planning perspective, is there any limitation from a planning perspective that would necessitate the reduction in the landscape buffer?
We did talk about that during the pre-application meeting, and I guess from our perspective, there you would just have a smaller footprint as far as your development would go to be able to maintain that buffer. But they may want to speak more to that. I'm not sure if there are specific reasons why the site has been designed the way it's proposed on the preliminary development plan, but they may be able to help address that a little bit better here in just a little bit.
Okay, perfect. And then my second question is regarding the entire property and maybe speaks to Commissioner Clark's question as well, just a little bit. From a planning perspective, is there any reason that this applicant is changing the zoning for all of these properties and could they in fact simply make an application for the property across the street rather than an application to change the zoning for all of these properties?
That's a great question, and I guess Hant may want to chime in here if I'm speaking out of turn, but historically, I think when we've had property already zoned, like in this case, all of the properties within the development, again, if I go back to the map, the zoning map, they were all rezoned together under the same development plan in 2003. So the proposed use that's before you this evening is, I guess, the required zone for the gambling facility is highway business. So they would need the highway business zone to accommodate their use. So we can't really apply to rezone from highway business to highway business since it's already highway business. And so the best avenue to achieve what the applicants have applied for would be to amend the development plan. But it just so happens in this case that the development plan involves multiple properties.
Okay, and so my question is going to get more specific here. Is there anything that prohibits us from let me see how to state this, from being more specific with these development plan conditions, rather than the development plan conditions being a blanket statement for the entire property. Can we speak specifically to the property across the street and not zone the entire portion of the property? I'm sorry, not allow the change in development plan conditions, more probably 15D and E would be the two that I think would come into play. So this is only from a planning perspective. Could we specify that D and E only apply to the property across the street and that everything else stays the same?
You could certainly ask the applicants if they were agreeable to that. I know in other development plan amendments, we have had situations where you may have one set of development plan conditions that applies to all tracts within the development, but then there have been cases where in addition to those, there may have been a final item added at the end that says, and for this tract only, the following restrictions apply. So that has happened previously.
Great. So just to clarify, I thought that was the case. I just wanted to make sure. And so just to clarify, from a planning perspective, there's no obstruction there. It's something that we could do if the applicant was amenable, correct?
Yes, sir.
All right. Thank you.
You're welcome.
Good. Rachel, could you possibly zoom in on the development plan that you've got up there now?
I will do my best. Give me 1 second and hopefully I don't mess this up. You want me to keep going? Is that better?
That is perfect for me. Thank you.
You're welcome.
That's awesome. Do you know if there's any kind of a hotel or anything, or is this just going to be a bar and gambling machines proposed?
You may want to ask the applicants, but it's my understanding that the main facility proposed at this time is a gambling facility, which is the proposed building shown on this plan.
Perfect. Thank you.
Any other questions before we hear from the applicant? No other questions? We'll go ahead and turn that over to the applicant. I don't know if that's Mr. Reynolds or, yes.
This is Buzz English. I'm here on behalf of Bowling Green Land Co., the applicant. I want to try to address some of the questions that have been asked. Also on the Zoom call are Jeff Arnold and Brian Shirley. I may have them address some of the technical questions. First of all, from the standpoint of the application, this original development was all was developed by Farmers Investment Company, and the reason that we have asked or have included the other properties is because we received a request from Farmers to do so. Also with the owner, also with David Sears, who owns the other tract or two other tracts of property within this, and that was the reason for that. Concerning the landscape buffer, we're asking that be reduced. Originally, there has been some talk about a greenway trail that will follow along the back portion of the property. We think it makes more sense to, similar to what's been done along Lover's Lane, is to provide additional sidewalks in the front. The current zoning requirement is for 15 feet, and we believe that this development, it would be better to suit this particular area to reduce that to 15 feet, but then allow for the additional space in the front for the greenway trail. Signage, we have addressed that. This property has been vacant for a number of years. We believe that most of the commercial developments now use 30-foot signs, which are within the zoning requirement for this, and that we feel that this would aid the development of this particular property. Other specific questions, please feel free to ask. As I said, Jeff Arnold and Brian Shirley are also on this. The others we also have representing the applicants, Mark Falcone and Ron Winchell, who are on here. So,
You have
Mr.
questions?
English, this is Tim Graham. I understand that your client has requested these changes for all of the property. However, my question for you is, are you at liberty on behalf of your client to restrict these gambling changes, if you will? More specifically, I think it's development plan condition 15 D and E to the property across the street on Ken Bale Blvd, rather than extend those to all of these properties.
let me say this: in this transaction, we're representing Bowling Green Land Co. That is fine with us, but there were other owners, particularly farmers, that own some of the adjacent property, and when we who currently own this property, and when we made this request, they requested that these same restrictions apply to, or excuse me, that these same changes apply to their property also. But I am not representing them in this transaction.
So who is representing them in this transaction?
This is Chris Whitfield, and I'm the attorney for the Bale family. And I believe that is something that they would be open to. And I don't have authorization to give a final okay on that tonight, but that's something I can certainly take to them. And I think that they would be acceptable to that.
So, Mr. Whitfield, I think the position we find ourselves in tonight is, in order to proceed with this, we're going to need a commitment from your client or from you.
Okay.
On those items. We can't speculate on what your client might do. We have to know what your client will do tonight.
Okay. If I may, I can place a phone call to Ruthie Bale, the chairman of the Bale family, and I can probably have an answer for you within a couple minutes, if that would be okay.
Fantastic. I appreciate your help.
Okay. I will log out. I'm on my phone, and then we'll log back into the Zoom meeting in just a minute.
Great. Thank you.
All right. Thank you.
Mr. English.
I'm sorry,
Yes.
Mr. Clark.
Go ahead.
Mr. English, could we go back and revisit the landscape buffer for just a moment? From your client's perspective, is there, so it is your client's position that the landscape buffer in the front, I think you described it as additional as sidewalks and et cetera, would be a better compromise than the landscape buffer in the rear. So does this property already have sidewalks?
No, it does not.
Okay. And this may be a question for staff. Are sidewalks required for this development?
Yes, sir.
Okay. And so, Mr. English, is other than the sidewalks, which would be required here no matter what we do, is there a physical limitation for this development that necessitates the reduction in the landscape buffer?
Well, actually, when you look at the back portion of it, and I'm sorry I'm not there, but what is there now is, quite frankly, it's a fence row with a few trees that have kind of grown up because it's along the fence. There's not in this area much of an existing landscape barrier at all. The current zoning requirement for this would be 15 feet, and what we're trying to do is to put that consistent with that. You also look at the adjoining property. We don't believe that there will be any, we don't believe that we think that a 15-foot will be sufficient to provide screening and other issues for the adjoining property. This will allow us to use more of the property for development purposes. And we think really the 25 feet or 25-foot requirement is not necessary for that. If I could ask Brian Shirley to also address this. Brian has been there and inspected this. Brian is with ACES and our engineer. Or Jeff, I'm not sure which one of you are on.
Commissioner Graham, one point of clarification. We have noted there are existing sidewalks now. That's in our staff report, and then you can see on the aerial in your packet, there are sidewalks that are already existing along Ken Bale, but the proposed amendment would allow for that sidewalk to be widened along the front portion of the property.
I apologize if I misstated on that.
That's okay. How much would it be? How much would it be extended, Rachel?
The minimum that's proposed is 8, but the final width would be coordinated and approved by staff, depending on future greenway plans in this area.
Okay, and before we get the engineers back on, let me ask one more question of staff, if I may. Why does this property? Why does it have a 25-foot buffer currently? And I think you addressed this in the staff report, but the answer escapes me.
Commissioner Graham, I'm not sure of the reason why the original buffer was imposed at the 25 feet, but that's just what was volunteered in 2003.
I see.
I'm not sure if that was directly related to public comment at that time or.
So it was volunteered at that time, but were it not in place currently, they would be required to have a 15-foot landscape buffer. Is that correct?
No, sir. The minimum in the zoning ordinance would be 10.
I see.
If there were no binding element or development plan condition.
Okay, perfect. And also in the staff report, I did see some drawings depicting some landscaping. I think that was submitted by Arnold Engineering. Are these drawings representative of the landscape buffer that they are proposing?
Let me see here. I think actually, if I could get zoomed back out here, I think that's on the same page we're looking at, and then we can zoom in.
It is. That's correct.
And so they've provided a typical buffer elevation here. This would be for each section of 100 linear feet along that, I guess, what would be the top or western property line in question where the buffer is proposed to be reduced. Mm-hmm. This was what was submitted with the application. This actually appears to match the zoning ordinance requirements as far as plantings go. The minimum per the ordinance is 6 evergreens and 3 deciduous per 100 linear feet. You can substitute some of your deciduous trees with ornamental trees, which is what it looks like they've done here. Again, they've called out at the top those existing trees to remain within that 15-foot area. Those would be supplemented with plantings to meet the minimum requirements in the ordinance.
Got it. And last question, that design depicts a fence, and so does this landscape buffer include a fence?
I believe that there's already a fence requirement in place. And it's number 8. It's the first part. That was the original proposal, and that's not proposed to change.
Okay, perfect. Thank you so much.
You're welcome.
This is Velma Runner, Mr. Arnold. I believe they had a question for you.
Yeah, I'll let Brian Shirley address the landscaping buffer, but I did want to add.
Well, let me swear you in. Excuse
Sure.
me. Your name and address,
Jeff Arnold, 208 Chippewa Drive, Bowling Green, Kentucky.
and you swear to tell the truth, sir.
I do, ma'am.
Thank you.
You're welcome. I did want to add that we're currently designing the last leg of the Ken Bale Blvd. Shive Lane extension that'll go out to Lovers Lane. And the Public Works Department requested 2 or 3 weeks ago that we widen the sidewalk on that new stretch of road so that it will accommodate the Greenways Trail. So you're going to have the greenways coming along Ken Bale Blvd. Or Shive Lane on the new section. And to us, it only made sense that we carried it forward all the way along this section as well.
And Mr. Arnold, just for clarity, that is in front or along the property in the front, not in the rear, correct?
That's correct. Along the road, just like the new section we're designing along the road. Yes.
I see. Thank you.
Brian, you want to address the landscaping?
Want to swear me in? Ms.
Yes, sir. Your name and address, please.
Brian Shirley, 1136 South Park Drive, and I do swear to tell the truth.
Thank you, sir.
I've gone on a site visit out and looked at a lot of the vegetation, and there's majority of the vegetation is fence row type plants. Most of them are not of a really good quality. A lot of them have been sheared on the backside by the utility companies on the apartment side. So we're going with this proposal and these plantings. We would be meeting the ordinance requirement, as Rachel stated, with inclusion of the fence. These plantings will be of a lot higher quality than was out there and provide a lot better visual buffer with the inclusion of the fence as well, and have a more managed look, more maintained look, and just overall better quality of plant material. Now, reducing that width from 25 to 15, still 5 feet and more than the ordinance requires. But as Mr. Arnold was saying, and Mr. English, that including the Greenway Trail in the front, we think makes a safer access for everybody instead of coming back to the rear of this property, kind of the rear of the house where the services are. So if the buffer is reduced or stayed the same, and then Greenway Trail went within that, it would effectively be making a 15-foot wide buffer. So taking that Greenway Trail and putting it to the front, then we were still achieving that same 15-foot width.
Brian, it sounds like y'all just Brian, it sounds like y'all just really trying to clean up the back of the property.
Yeah, the majority of it is
Okay.
not real good vegetation.
Okay.
Madam Chair, I apologize for interrupting, but it does appear that Mr. Whitfield has returned to the meeting.
Oh, thank you, sir. Mr. Whitfield.
Yes, ma'am. Yes, sir. Are you able to hear me?
Yes, sir.
Okay. If you need to swear me in, my address is 1761 Euclid Avenue, Bowling Green, Kentucky, and I do swear to tell the truth.
Thank you, sir.
So I have spoken with Ruthie Bale, and she has given authorization to agree that the gambling restriction could apply just to the 16-acre tract that's being questioned here, and does not have to apply to the remainder of the property that they own.
Perfect. Thank you, sir.
Yes,
And let
thank
me
you.
also say,
Let me, if I might, kind of put some focus on, I think, this issue. First of all, let me point out that this is an application that has been filed by Landco as is stated, but because it is an amendment of development plan conditions, it requires that all of the property owners join in the application. And so what's being discussed here is an amendment to that application. It sounds as though that Farmers Investments has agreed to amend the application, but I just would point out, as I'm sure Mr. English is aware, that Sears development. I don't have the plat in front of me to see the other property owners, but my memory tells me that there's Sears Development, who is a property owner, as well as Sam's Land Trust that is also a property owner, and there may be others that would also need to agree to the amendment of this application.
Mr. Moore, this is, we had 75% of the owners who agreed to the amendment. I believe Jeff Arnold has spoken with David Sears, who owns S Industrial Properties, Inc., and also Sears Development Property, Inc. And it's my understanding that he has agreed to the proposed amendment for the gambling change just to apply to this particular tract of property.
Mr. English, that's correct. I called him when this discussion started, and he agreed that he doesn't really want the gambling on his property anyway, so he's fine with that.
So are you representing then that 75% of the property owners have agreed to this application amendment?
Correct.
Okay. And Mr. Arnold, you're the engineer and surveyor. Do you also concur in those with those numbers?
Yes.
Okay. And so if you would please, Mr. English, if you would give us the amendment you want to make to this application.
The language that.
Yes, sir. And, you know,
I guess we just limit it to I guess what they're asking is to comply with what Mr. Graham's saying, is to have 15 D and E applicable only to lot number 2.
Correct.
I believe that the amendment would be that we would have 15
D and E.
15 D and E of the development, general development plan amendments only apply to which section is
It's lot number 2.
Lot number 2. Is that sufficient, or could?
Yeah, I'm just trying to make sure that that's clear to me. And now I want the record to be clear that that amendment has been agreed to by the applicant, Landco. It has been agreed to. Mr. Whitfield, you speak on behalf of Farmers Investment Company Incorporated.
Yes, that is correct. I'm authorized to speak on their behalf.
And Mr. Arnold, you represent that you speak on behalf. Let me get to the plan. It's not up on the screen.
It's H&S Industrial Properties, LLC, and Sears Development Group, LLC.
Okay. What is the, there's a piece of property in what I would call the, I guess, the southwest corner of this tract that's on the other side of Ken Bale Boulevard and Nell O'Brien Court. Who's the owner of that drainage easement?
The Bale family is the Farmers Investment.
That's Farmers Investment. Okay, thank you. So, Mr. Arnold, do you think we have we identified all of the property owners in this concept plan?
Yes.
Okay.
With the exception of Sam's Real Estate Business Trust, but for this application, those signatures for that owner were not included to get to the 75% minimum required.
Gotcha. So would it be correct to say that the properties that are shaded in green are the properties that joined in this application?
I think the concept's a little deceiving. Let me jump back to the previous screen. And so the properties subject to the application are all of those shown here.
With the exception of Sam's Real Estate Business Trust.
No, that's part of the development, but for the amendment, we only require 75% of the owners to agree to the amendment.
But what I was trying to make clear is that all of the property owners in the development have joined in the application.
No, sir.
No, 75% join in the application.
The only one that hasn't is the Sam's Real Estate Trust. All other property owners have agreed, which is 75% of the owners.
Mr. Moore?
All of the property owners in the, shown in the concept plan B joined in the general development plan amendment with the exception of Sam's Real Estate Business Trust.
Yes, sir.
Okay. And that constitutes 75% of the property owners.
Yes.
Yes, sir.
And that 75% pertains to the square footage of land as opposed to the number of property owners.
The number of property owners.
The number of property owners.
Yes.
Okay, thank you. Sorry to be what maybe seems
Or I guess to further clarify, the number of parcels of land subject to the development plan amendment.
okay. Thank you.
Mr. Moore? Pam? Can you hear me?
Yes, sir. I can hear you, Mr. Stark.
When we develop the language to this, can we make sure that we specifically identify by name the 75% of those owners?
Yes, and I think
rather than just by percentage, identify by name, please.
yeah, as I understand it, the property owners who have agreed not only to the application, but this amendment, those property owners are Farmers Investment Company Incorporated, Land Co., who is, I guess, a contract vendee, BG Land Co. LLC, Sears Development Group LLC, and I believe those are the property owners that have agreed to the amendment. And they constitute 75% of the owners.
Okay, thank you.
Mr. Moore, we need to add that H&S Industrial Properties LLC was also one of those property owners that agreed.
H&S is the David Sears property.
Correct.
If it's helpful, the owners are listed on page 21 of your staff report.
Can we go back to the landscaping thing with Mr. Shirley, if everybody's satisfied with this part?
Yes, ma'am. Go ahead and ask your question.
Mr. Shirley, is that going to be a full solid wood fence all along the back?
Yeah,
As well
dividing
as the
elements,
plantings?
the development plan conditions require that the entire property line have that.
And it will be a solid wood fence as well as all the plantings.
Correct.
And that will keep the light off the hotel and off the RM4 properties.
Yeah, the
with
lighting
only
is all going to
15
have
foot.
to be, the lighting is all going to have to be directed inward and downward onto the site. And any pole lights would be in the back, would have shielding on them to keep any lights from going that direction.
And then a question for the applicant, it's just going to be a bar and a gambling facility, or is there going to be a hotel involved here? And is there going to be deliveries to this place in the back of this building?
First of all I can talk about is what is currently on the concept plan, and there's not a hotel that is within the original concept drawings that are developed. I can't speak to future development. All I can talk about is what's here. There right now a hotel it is not. Now in terms of what else it will be, it will also hope at some point we're hopeful for restaurants and other types of development or other types of places to eat, so forth, would be included. But right now, this is what we have planned is on the drawing.
So do you think deliveries and everything made to these buildings will be made from the back? And you think a 15-foot landscape buffer will be enough to stop the noise and everything from those deliveries?
I believe it will be. I mean, you look on the drawing and look at the placement of the building, it's a significant difference, or excuse me,
Rachel, can you zoom in towards the back of the building?
Sure thing.
So you can see towards the rear of the building, kind of we'll call it the northeast corner, the loading area or service entrance would be right where her cursor was just a second ago. So that's going to be probably 40 feet from the property line, and with additional green space and the island between the travelway and where any trucks would be.
But doesn't that show a 25-foot landscape buffer right there where it's zoomed in?
That is currently what is required by the existing binding elements. So we'd be reducing that to 15 feet.
Mr. Shirley, just as a point of clarification, when you say you're going to reduce it to about 15 feet, does that mean that the building would be closer than what's represented here, or that this landscape buffer isn't depicted in the spot it would actually occupy?
Yeah, this landscape plan shows it as a 15-foot wide buffer.
Okay, and so only the text depicts a 25-foot buffer. Is that correct?
Correct. That is correct.
I see. Okay, thank you.
Have any other questions for Mr. Shirley?
I have a question for the applicants whenever.
Yes, sir. Go ahead.
Mr. English and the attorney representing the proposed development, on page 9 of our staff report, you all gave a narrative on pages 7 and 8, basically talking about the Kentucky horse racing, and there's not a better location than Bowling Green, Kentucky on page 7. But if you go to page 9, there's two things that this board needs to consider, and the city commission, and that is about 2/3 of the way down the page. The planning commission should determine compliance with ED1 if the proposed development plan amendment to allow additional uses, specifically gambling facilities and establishments with more than 60% of the seating being located at freestanding or other type bar, will help attract new businesses, particularly those that help diversify the local economy. The next one, planning commission should determine if the proposed development plan amendment complies with ED 9.1 and if it will provide additional opportunities for tourist support facilities. So I'd like for you all to address that. And my question is that there is a the same facility 20 miles down the road, and how this would provide for additional tourist support facilities in ED 9-1.
Well, we anticipate that when this facility is completed, there will be a number of employees that will work at this facility. We also believe that this is a form of entertainment that will attract tourism to the area. We believe that historical racing is something that is consistent with Kentucky history. It has been this past legislative session, the legislature and the governor approved historical racing facilities such as this. We believe that this facility is appropriately located close to I-65 and the interchange, and with the new connector with Ken Bale Blvd and to Cemetery Road, this is probably the best location in Bowling Green and Warren County for a facility such as this. I don't know if that completely answers your question, but we'll be happy to, if there's something specific that you would like for me to address, to try to address.
Buzz, you did a great job, but I'm just saying additional on ED 9-1 tourist support facilities. My question is, we've got the same facility 22 miles down the road. What is the additional tourist support facilities having one 22 miles down the road and one here in Bowling Green?
If I'm driving in the northerly direction or from the north in a southerly direction and coming from the north, I would much rather stop in Bowling Green than I would in Franklin.
Okay, thank you, Buzz.
I mean, the other type of, I think we anticipate that there will be restaurants and other tourism type places for traffic off the interstate that will spur development and that type of development in this area.
Thank you.
Mr. English, I have a question.
Yes, sir.
And you can answer this, or maybe the proposed developer can. Has there been an economic impact analysis conducted for this proposed development of any kind to determine the full-fledged economic impact that this proposed development will have? And
not to my knowledge, a formal economic impact, what you would typically see. I am not aware of one that has been conducted. We have obviously talked to Ron Butch at the Chamber of Commerce and others who are, we believe, are fully in support of this. But in terms of, can I point to you a specific economic study that's going to say that this facility, once open, will generate this many jobs, this much tax revenue, this much economic spending within the community? I'm not sure specifically that type of analysis has been completed, but we think the impact would be significant and very positive.
Thank you.
And do we have any idea how much traffic this is going to impede? Because I know on Saturday afternoon, trying to get to Sam's is almost impossible right now. So if we have, how many cars are we anticipating to adding to Ken Bale Blvd?
Yes, ma'am. We have submitted a traffic study that includes those numbers. We also have agreed to before we open at this facility to install a traffic signal at the intersection with Sam's. And we also believe that the extension of Ken Bale Boulevard to Cemetery Road will significantly improve traffic flow in that area once that's completed by the city.
Buzz, if I
Is
might
it-
add, go ahead.
Is the light going to be down by the gas pumps or up by the farm place in Sam's? Which entrance? You've lost me there.
Believe it's the one closest to the farm store.
Commissioner
Yeah,
Clark.
right there,
Can you
right
see
there.
his hand on the screen and be right here?
Elma, do we have people in opposition?
I believe we do. Do we have any other questions or comments from commissioners? No other questions from our commissioners? I believe we have opposition to this request. Do we have a spokesperson for the group, or do we have individuals to speak? No spokesperson? The first person that would like to speak is that Ben Simpson. If you
Yes, that's correct.
state your name and address, please.
Ben Simpson, 900 H.E. Johnson Road, Bowling Green.
And you swear to tell the truth, sir?
Yes, I do.
Yeah, you can go ahead and ask a question, please.
Thank you guys so much for what you do. It's amazing to sit and listen to this discussion and just the detail that you guys go into. So thank you for what you do. I speak as a pastor in this community, and I just want to encourage this commission to keep in mind that you've been established for the benefit of our community, and a community like Bowling Green in general. Y'all's job, in my opinion, is to protect our community, to uphold things that are good. And when I look at the proposal here, I see something coming to Bowling Green that will be a blight on our community. Typically, when you see casinos and things of that nature come into a community, they typically they typically target the poor. The slot machines and the things that they're going to be doing are rigged, you know, to take advantage of our people. And yeah, I heard someone call this entertainment, and certainly some do, but it's also a situation where you're preying on people. We'll be basically encouraging the weakest among us to be preyed upon in these situations. So as a commission, I would strongly encourage you to protect our community from establishments such as this. It's already been stated very well that there are facilities right down the road in other counties, or they could go north as far as that goes, just an hour or two away. We do not need this in Bowling Green. Please protect our community.
Thank you, sir. Do we have someone else, please? Anyone else that would like to speak or give us additional information?
I do not see anybody else.
No one else? Commissioners, do you have any other comments, questions before we go ahead and have Mr. English, if you'd like to make any kind of closing comment before I call for a motion?
Just very briefly, we believe that we have proposed a development that will be good for the community. We're not targeting anyone. This is a form of entertainment that is coming to this area that the legislature has authorized. This is the best location and development for this facility. We'd ask the commission to approve it. Thank you.
Thank you, sir. Commissioners, you have any comments before I call for a motion? Is everyone clear on the development plan and what's been restricted or taken out of this amendment?
Yes.
Then I'll ask for a motion, please.
I make the motion to deny the proposed general development plan amendment docket number 2021-10 DP based upon the testimony and documents presented in this public hearing. The proposed general development plan amendment is not consistent with the adopted Focus 2030 comprehensive plan as demonstrated by its non-compliance with objectives and action items presented in the staff report. Items not in compliance, LU2, LU2.52, ED1, ED19. Further, find that there have not been major changes of an economic, physical, or social nature within the area of this property in question, and request the finding of fact and recommendations include the summary of evidence testimony presented by the witness public hearing.
Thank you, Mr. Warren. We need a second.
Second.
Thank you, ma'am.
Madam Chair, let me tell you, of course, that you have before you a motion to deny the amendment. So your vote requires some additional thought. If you are in favor of denying the amendment, then you should vote yes. If you are in favor of granting the amendment, then you should vote no. A yes vote is against the development. A no vote is in favor of the development.
Thank you, sir. We have the roll call, please. Thank you.
Commissioner Warren,
Yes.
Commissioner Blackburn,
Yes, ma'am.
Commissioner Clark,
Yes.
Commissioner Graham,
In light of the concessions, no.
Commissioner Ritchie,
Yes.
Commissioner Starks,
Yes.
Commissioner Unseld,
Yes, ma'am.
Commissioner Vitale,
No.
Commissioner Volkert,
No.
Chair Runner.
Yes. Motion carried. The motion.
There appear to be 7 votes yes to deny and 3 votes no against denial. So the denial motion has carried.
Thank you, sir. Thank you all. And we'll move on to the next item.
Okay. We're gonna get research here.
We'll let y'all swap. The next item, docket number 2021-31 ZBG, Keeping It LLC, care of Jennifer Sharber, has filed an application to rezone a tract of land containing approximately 0.325 acres located at 1244 Magnolia Street from RM3, which is Townhouse Multifamily Residential, to OPR, Office and Professional Residential, with a general development plan. Also, that same applicant on docket number 2021 V12 has applied for variances and a waiver at that same property, which is currently zoned RM3. And we will have the staff report from Ms. Ramsey.
Thank you, Chair Runner. It's a good thing that one was kind of long, because it took Rachel and me a second to get everything switched back in place. So,
Thank you.
we had a pre-application conference on March 16th for the property you see outlined in yellow, which is currently zoned RM3, Townhouse Multifamily Residential. Current use is single family, and in the area, we've got kind of a mixture, single family, commercial, some multifamily in there, and then you see some vacant lots, public and public institutional as well, with future land use map designation of mixed use residential. Okay. So the applicants this evening are making their rezoning request in order to allow an office use on the property. The applicants are also requesting variances for the required side yard setback and the required landscape buffer between a vehicle use area and a common property line, and a waiver for lot coverage. So we will touch on that more in just a second. Staff has noted on the first page of your staff report there, under the compatibility with surrounding development, that there are some mature trees located on the rear portion of the property. Going on to page 2 of your staff report, under the layout, lot size, and setbacks, just wanted to note that the applicants are planning to repurpose the existing structure and site for an office use, more specifically bookkeeping. The external appearance of the property should remain generally the same. And staff has also noted under the site design and compatibility review, very last thing, their proposed open space, I'm looking at page 3 on the staff report, that the maximum allowable lot coverage in the OPR zone is 50%. The applicants have requested a waiver to allow 60% lot coverage, meaning 40% of the property will remain as open space. The applicant supplied 7 development plan conditions. I'll go ahead and read those. Number 1, non-residential uses on the property will operate between the hours of 9 a.m. and 5 p.m. Staff may be present on the property outside of normal business hours as long as there are no customers or clients present on the property during this time. Number 2, access to the property will be coordinated with and approved by the Bowling Green Public Works Department. Number 3, vehicle use areas will be shielded by a combination of a 6-foot privacy fence and the installation of landscaping in compliance with the zoning ordinance. Number 4, existing trees on the property will be preserved when feasible based on location, type, and condition. Number 5, any freestanding signage will be limited to monument style, no taller than 4 feet and no larger than 20 square feet per sign face. No LED signs will be allowed. Signs will only be lit from the outside. Number 6, any new structure on the property will be architecturally compatible with the surrounding structures and shall be residential in appearance. The layout of any new structure on the property will allow for the building to be utilized for both office and residential purposes, or be able to be converted easily for residential purposes. Any new structure on the property will have a front facade oriented toward Magnolia Street. The maximum building height for any new structure constructed on the property will be 2 stories. Metal, plain face block, and split face block shall be prohibited as visible exterior materials for any new primary structure constructed on the property. And number 7, if the property is ever redeveloped, parking associated with any non-residential use shall be located behind the front facade of the primary structure. We'll go on to our Focus 2030 category review. Staff evaluated 14 items, 5 of which comply and 9 of which are left up to your determination or generally comply. The latter would be LU 113 if the proposal is compatible with the area. LU2 if the proposal will result in high quality development that will protect the character of the area. LU214 and NCR 116, this is in reference to the development plan condition on trees, that it generally complies with those. LU25, LU252, if the proposed development is a compatible infill project and if it will stabilize and protect the existing neighborhood. HN1, HN13, if the proposal is a compatible infill project that will maintain or improve the existing character and pattern of development within the area, and if it will strengthen the existing neighborhood. And ED1, if the proposal will strengthen and diversify the local economy. Now we're going to move on to the section with the that references the variances and waiver requested. You have there the references from the zoning ordinance in Article 4, the first of which stating that the side yard setback in the OPR zone is 10 feet. The applicants are requesting a variance of 4 feet from the required 10-foot side yard setback, and that is in reference right here, if you can see where my cursor is. So on the bottom left of the concept here, where the red writing is. The next reference there, the applicants are requesting, I won't read all that, but the applicants are requesting a variance of 3 feet from the required minimum 5-foot landscape buffer between a vehicle use area and a common property line. That is in reference to the right side over here, and it shows the red writing here depicts where that is shown, the vehicle use area of the driveway, in other words, going back to the rear portion of the property for the new parking lot. They like to reduce that landscape buffer. And the last, I've already touched on about lot coverage. That's detailed on this concept in red off to the side, but the applicants are requesting a waiver of 10% to allow 60% lot coverage. On the next page of your staff report, you have there the variance findings from KRS that we can touch on if you would like, but they're there for your reference. The waiver findings are also listed there. I will note letter E, we have a note there that the findings, one of those is that the extent of the waiver of the regulation minimum necessary to afford relief to the applicant. The proposed lot coverage listed on the variance exhibit, 58.2 square feet, meaning a waiver of 8.2 square feet is the minimum necessary to afford the applicant relief. Staff suggests revising the application to request only the minimum needed as stated in the findings above. The applicant indicated, I'm sorry, that should be percent, not square feet, I believe. The applicants indicated that they understand the purpose of this finding, but expressed concerns as to whether or not the paving crew will get the parking area so exact that the lot coverage will end up at a perfect 58.2% impervious. For this reason, their request was rounded up to a waiver of 10%. And lastly, I'll note on the next page that the applicants did submit a narrative there for your reference for their requested variances and waiver. I will go back to page 1. We have our points to consider. And so this board should, with this proposal is consistent with the flume and mixed use residential category. The proposed development complies with the majority of the site characteristics review criteria, with the exception of the side yard setback, the required landscape buffer between a vehicle use area and common property line, and lot coverage, for which the applicants have requested variances and a waiver. And this body should consider if the requested variances and a waiver arise from special circumstances which do not generally apply to land in the general vicinity, and if the strict application of the provisions of the regulations would deprive the property owner of the reasonable use of the land. This body should further consider if the argument provided by the applicants addresses the findings required to grant a variance and waiver. The proposed general development plan complies with the majority of the review criteria for site design and meets the minimum requirements in the zoning ordinance, and compatibility of this development is left to your all's determination. So that is all I have for the staff report. I haven't looked. I believe the applicants are with us, but I'm happy to answer any questions you may have for me.
Thank you, Ms. Ramsey. Commissioners, do you have any questions?
Monica, are the variances and the waivers primarily to address parking and traffic flow?
Commissioner Graham, I'll have to go back over here so I make sure I don't misspeak, but the existing structure, as I understand, is already closer. Where you have the vehicle use area there. I know there is an existing driveway, and the applicants may set me straight on this as far as how much paving they're wanting to do, but the paving area in the back would all be new, and so with the lot coverage and the vehicle use area for a commercial use, since it would not be, if this were to pass, it wouldn't be a single family, or it wouldn't be a residential home anymore, then the nature of the use of the property necessitates those new requirements. And so
I see. So the requirements go up, if you will, when the property, even though they're using the same structure, the requirement would be greater if it was used in a different capacity, correct?
I may have misspoken there.
No, I think so. And I guess The easiest way to explain it, just to be frank, is that the width of the lot could not accommodate a one-way travel way with parking and the landscaping. The lot is too narrow to simply be able to do that and meet the minimum landscaping requirements. So, and I think just given the existing drive that comes in at the bottom part of your exhibit there, that's already there. Given the location of the structure, there's simply no way without completely redeveloping the site and starting from scratch to meet our requirements.
See, all right,
And
thank you.
repurpose the property for commercial or for office use.
Okay, thank you.
Any other questions? Commissioners, do you have any other questions? Ms. Sharber, are you online?
I am.
Yes, this is Velma Runner. I just wanted to see if you had anything you wanted to add, and if you do, I'll swear you in and let you do that.
I don't think I do.
Okay, any questions? I'll see if we have any questions for you. Any
Ms.
questions?
Runner,
Yes.
this is Rodney McGee. I have something I'd like to add. as
Yes,
the
sir.
engineer.
If you'd state your name and address, please, sir.
Yes, ma'am. Rodney McGahee, 2053 Dyford Road.
And you swear to tell the truth.
Yes, ma'am.
Thank you. Go ahead, sir.
Commissioner Graham, I wanted to kind of speak to something that you brought up there. The existing setbacks for this RM3 lot are 7.5 feet, and by going to OPR they jump to 10 feet. So it's more restrictive, like you were suggesting. And also the reason for both of those variances is because we're going to OPR. It's not because of the additional pavement in the rear. It's because of the existing condition that it's in right now as it sits. And also I'd like to note that in RM3, you're allowed up to 80% impervious on this lot. And we're only asking for a slight 10% increase to get to 60%. So it's going to be less than it could be if it stayed RM3, even though we're changing uses. I just wanted to make a point there.
Great, that's good information. I appreciate your help.
Thanks, sir.
Thank you, sir. Do we have any questions for Mr. McGay or the applicant, Ms. Sharber? No other questions? Do we have any opposition to this request? Have anyone online with a question or opposition? I don't see anyone. No one? Then I will call for a motion. And I'm sure as you've noticed in the packet, we first need to address the zone change request. That will be one of 3 motions. The second will be for the variances, and the third for the waiver. I'll ask for that motion for the zone change.
Make a motion to approve the proposed zoning map amendment together with a condition upon the general development plan docket number 2021-31 ZBG. Based upon the testimony and documents presented in this public hearing, the proposed zoning map amendment is consistent with the adopted Focus 2030 comprehensive plan, as demonstrated by its compliance with the objectives and action items presented in the staff report. Therefore, the proposed zoning map amendment is in agreement with the adopted comprehensive plan. Further, I request this motion includes a summary of evidence and testimony presented by the witnesses at this public hearing.
Thank you, sir. We need a
Second.
Thank you.
Commissioner Volkert, did you second that, sir?
I did, Rachel.
Thank you. Commissioner Graham,
Yes, ma'am.
Commissioner Ritchie,
Ma'am.
Commissioner Starks,
Yes, ma'am.
Commissioner Unseld,
Yes, ma'am.
Commissioner Vitale,
Yes, ma'am.
Commissioner Volkert,
Yes, ma'am.
Commissioner Warren,
Yes, ma'am.
Commissioner Blackburn,
Yes, ma'am.
Commissioner Clark,
Yes.
Chair Runner.
Yes, ma'am. The motion carried, so our recommendation will be approval. And now we need to act on the variance request. I'll ask for that motion, please.
I make a motion to approve the variance request for variances at 1244 Magnolia Street, docket number 2021 V12. And there are two items, one variance from 4 feet from the 10-foot yard setback and variance of 3 feet from the minimum required 5-foot landscape buffer between a VUA and common property line. The testimony presented in this public hearing has shown that granting these variances will not adversely affect the public health, safety, or welfare, will not alter the essential character of the general vicinity, and will not cause a hazard or nuisance to the public, and will not allow an unreasonable circumvention of the requirements of the zoning regulations.
Thank you.
Second.
Thank you.
Commissioner Graham,
Yes, ma'am.
Commissioner Ritchie,
Yes, ma'am.
Commissioner Starks,
Yes, ma'am.
Commissioner Unseld,
Yes, ma'am.
Commissioner Vitale,
Yes, ma'am.
Commissioner Volkert,
Yes, ma'am.
Commissioner Warren,
Ma'am.
Commissioner Blackburn,
Yes, ma'am.
Commissioner Clark.
Yes.
Chair Runner.
Yes, ma'am. And the motion carried. And the third and final is for the waiver request. I'll ask for that motion, please.
I make
I'll make the
the,
motion to, go ahead, Commissioner Starks.
I make the motion to approve the request for a waiver at 1244 Magnolia Street, docket number 2021-V-12, a waiver of 10% to allow 60% lot coverage. The testimony presented in this public hearing has shown that the granting of this waiver will not adversely affect the public health, safety, or welfare, will not alter the essential character of the general vicinity, will not cause a hazard or a nuisance to the public, and will not allow an unreasonable circumvention of the requirements of the zoning regulations. I further find that the waiver will not violate the comprehensive plan. The extent of waiver of the regulation is the minimum necessary to afford relief to the applicant, and either one, the applicant has incorporated other design measures that exceed the minimums of the district and compensate for non-compliance with the requirements to be waived, in parentheses, not beneficial effect, or two, the requested waiver arises from special circumstances which do not generally apply to land in the general vicinity or the same zone, or three, the strict application of the provisions of the regulations would deprive the applicant of the reasonable use of the land or would create an unnecessary hardship on the applicant.
Thank you, sir. We need a second.
Second.
Thank you, ma'am.
Commissioner Starks,
Yes.
Commissioner Unseld,
Yes, ma'am.
Commissioner Vitale,
Yes, ma'am.
Commissioner Volkert,
Yes, ma'am.
Commissioner Warren,
Ma'am.
Commissioner Blackburn,
Yes, ma'am.
Commissioner Clark,
Yes.
Commissioner Graham,
Yes, ma'am.
Commissioner Ritchie,
Yes, ma'am.
Chair Runner.
Yes, ma'am. And again, the motion carried, and we thank you all. Next item, docket number 2021-14 Flume. Joseph Scott Rippey and Jerry D. and Sheila Hester have filed an application for a future land use map amendment on tracts of land containing approximately 5.68 acres located at 0 Boyce-Fairview Road and 0 Woodburn Allen Springs Road, which is behind and beside the Boyce General Store, from agriculture to rural density residential. Also on docket number 2021-32 County, those same applicants have filed to rezone that same land at that same address from agriculture to rural, to a residential estate with a general development plan. And we'll have the staff report from Ms. Ramsey.
Thank you, Chair Runner. We had a pre-application conference on April 21st for the properties you see outlined there in green. Properties are zoned agriculture and they are currently vacant. In the area, you mostly have agricultural uses and single-family residential. Of course, the Boyce General Store is right there adjacent. And in the area, it's primarily agriculture and with some rural density residential. This area may look familiar to some of you. And we'll talk more about that in just a second. But the applicants this evening, as you can see from the concept, they would like to, with their requested flume and zone change, develop the property for a maximum of 5 single-family residential lots. That would lead to a density of 0.88 dwelling units per acre. Staff has noted under the compatibility with the surrounding development on the first page of your staff report that a site characteristic review indicates that there are adequate facilities and infrastructure available to support the proposed development, with an exception noted regarding road width. And that is that's in reference to Boyce-Fairview Road, which has 14 feet of pavement width. On the second page of your staff report, you'll see there the applicants included a narrative to address the procedures for amending the future land use map. I won't read that, but it is there for your reference. Further, on the site characteristics review, going on to the next page, that prime farmland, this development contains soil types that are classified as prime farmland and farmland of statewide importance. And soil suitability, there are soil types that are classified as somewhat limited and very limited regarding soil suitability for septic tank absorption fields. Under the site design and compatibility review, there are several items there, but I'll touch on that the surrounding density. Within a quarter mile, densities range from 0 to 1.43 dwelling units per acre, with a median density of 0.20 dwelling units per acre and an average density of 0.40 dwelling units per acre. Within a half mile, densities range from 0 to 1.43 dwelling units per acre, with a median density of 0.29 dwelling units per acre and an average density of 0.44 dwelling units per acre. And again, the proposed density as a result of this application would be 0.88 dwelling units per acre. The applicants have supplied 7 development plan conditions. I'll go ahead and read those. Number 1, no manufactured homes will be permitted on the property. Number 2, any new residence constructed on the property will contain a minimum of 1,500 square feet of conditioned living space and shall contain a minimum of a 2-car attached garage. Number 3, each residence shall be constructed of brick, vinyl, concrete siding, or stone. No visible plain-faced block foundations will be permitted. Number 4, any new lot shall obtain a site evaluation from the Barren River District Health Department prior to recordation of the plat. Number 5, the property shall be limited to a maximum of 3 access points to Boyce-Fairview Road and 2 access points on Woodburn Allen Springs Road. And they are to be coordinated with and approved by Warren County Public Works Department and the Kentucky Transportation Cabinet. Number 6, residences constructed on lots fronting Boyce-Fairview Road will have a front facade oriented toward Boyce-Fairview Road, and likewise for Woodburn Allen Springs Road. And number 7, the front building setback for all lots shall be a minimum of 50 feet. Under the Focus 2030 category review, there were 14 items that staff evaluated. This application complies with 4 of them, and 10 of them are left up to your determination. LU 111, 112, and 113. Proposal may comply with the flume, and those first 2, if deemed compatible with the surrounding area, the flume amendment is approved. And if the Planning Commission determines that the proposal is complies with LU 113, dealing with compatibility. LU 2, this body should determine if the proposal is a high quality development that includes design standards tailored to preserve the character of the area. NCR 24, if the proposed development will preserve the existing agricultural landscape and viewshed, and if it will enhance the rural character of the Boyce community. NCR 241, that is in reference to the road width, and so this body should determine whether or not the proposed lots will result in an increased amount of development pressure on the countryside. LU 29 and NCR 25. This body should determine if the 5 proposed RE lots will promote the vitality of the existing rural landscape, if the proposal is in keeping, and if the proposal is in keeping with the character of the Boyce community. And HN21, HN4, if the location of the planned development is suitable for the proposed housing type, and if the proposed residences are believed to enhance the array of housing options available in the area. I'm going to go back a few slides. I'll just pull this up. This is easy enough. Since it's pretty well coordinated here, that we can see these lots. So like I said, this may look familiar to some of you, and maybe all of you. I think everybody was on the commission then, but the subject properties are 2 of 8 lots subdivided from 41 acres resulting from an auction in 2020. The applicants are proposing to further subdivide the subject properties into a total of 5 1-acre single-family residential lots. The adjacent development, referring to this, that was amended to rural density residential and rezoned. The adjacent development was also part of the original 8-lot subdivision and was rezoned in 2020 and subdivided into these 5 lots you see here. If approved, if this application is approved, the total number of lots resulting from the original 41 acres auctioned in 2020 would be 15, almost doubling the original number of lots from the auction. And so where you get the 15 is that there was other land aside from just these 2 overall parcels, but the overall number would be 15. So going back to the points to consider on page 1, the Planning Commission should consider if a FLIM amendment to create 5 additional lots in the proposed location is appropriate for this area of Warren County and the Boyce community, and further consider if the argument provided by the applicants to amend the FLIM meets the criteria outlined in LU 114 of the comprehensive plan. If the FLIM amendment is approved, the proposal would be consistent with the FLIM and the rural density residential category. The proposed development complies with the majority of the site characteristics review criteria, with considerations noted regarding road width on Fairview Road. The proposed general development plan complies with the majority of the review criteria for site design and meets the minimum requirements in the zoning ordinance. And compatibility of the proposed development, including the proposed density, should be determined by the Planning Commission. That is all I have for the staff report, and I'm happy to answer any questions.
Thank you, ma'am. We have questions from Ms. Ramsey.
Monica, this is Tim Graham. What is the significance of the number of lots that are now resulting, if this is approved, and the number of lots that were proposed at the auction?
The significance?
Yes, ma'am. You pointed out that this would result in, I can't remember the number, but like I think it was like 15 lots. So I'm trying to understand how that correlates to the original auction.
I'm sorry, I'm not sure I'm still understanding your question. So in other words,
Tim, Tim, I think she was just saying from the original 40. I think she was just saying it's just being cut. I think she's just saying it's being cut up into smaller lots.
I see. Okay. All right. Thank you. I think I misunderstood.
Okay. Yes. Yeah. That's essentially what we're saying. Just pointing out
we were just, I guess, trying to paint a picture of kind of the history of this property, because on the face of things, it may look like these have been separate requests from multiple properties, just so the commission knows that this was all part of the same parent tract from that original auction back in 2020, from that original 41 acres. And it's just kind of to give you a history of how this land has developed over time.
The lots have doubled, Tim. It was 8 in the original auction and now it's 15.
Okay. All right. Thank you.
Any other questions, Ms. Ramsey? No other questions. We have the applicant present. That's Mr. Rippey.
Yes, ma'am.
Yeah, is there anything that you would like to add, sir? If there is, we can swear you in and let you make a statement.
No, ma'am.
No, ma'am. Okay, thank you, sir. I'll just ask, do we have any opposition to this request? Do we have anyone online with a question or opposition?
I have a question.
Yes. Your name, please?
Dean Warren.
Oh, I'm sorry. I didn't realize that was you, sir. I didn't recognize you. Now I know who you are.
Here, I'll take my glasses off. I gotta put my glasses on to read.
There you go, sir.
On page 4, the applicant, Mr. Rippey, on number 3, Each residence shall be conducted of brick, vinyl, concrete, siding, or stone. No visible plain face, block foundations will be permitted. Mr. Rippey, what would you commit to? Is this going to be all vinyl, all concrete siding, brick? What percentages would you be willing to commit to these new homes?
And this is Velma Runner. I apologize, since you've been asked a question, let me swear you in really quickly. If you give us your name and address.
Scott Rippey, 8268 Knob Hill Road, Alvaton, Kentucky.
And you swear to tell the truth, sir.
Yes, ma'am.
All right, now you can answer the question. Thank you, sir.
I would say it would be up to the builders, and I mean, I can't give a percentage because I really don't know.
Mr. Rippey, I think what Dean is asking, if you'll commit to a certain amount, then they'll have to be built to that standard. And one of the things that we do in these meetings is we will make sure that the houses that are built, we just try to keep them to a standard. So I think what he's asking, would you commit for them to be at least 60% brick?
I mean, I'm just selling the lots. I mean, I would have to work that in this here. Like I've got to show 60% of them is going to be brick.
If I may interject just for a second, the development plan conditions that were submitted here, the Rippies also did this development we were talking about earlier along Woodburn, Allen Springs. I'm sorry, I think I misspoke, but the development plan conditions are identical as they're presented tonight. They're identical to these for that were approved in 2020. Just for reference. So just wanted to point that out.
Dean, you okay with that?
Yes, sir. I just didn't know. I'm sorry.
Yeah, no, I agree. Well then, Mr. Rippey, I think we're fine with what you presented.
All right. Thank you, sir.
Yes, sir.
Do we have any other questions?
So do we have a percentage? I'm totally lost
No,
there.
we don't have a percentage. Just like the other lots that were done in 2020, they're going to match the same as those, and those do not have a percentage either.
Any other questions before I call for a motion? Nothing else? I'll ask for a motion for the Flume amendment. That will be our first motion.
I make the motion to approve the proposed Flume amendment, docket number 2021-14 Flume, based on the testimony and documents presented in the public hearing. The proposed Flume amendment has met the directive to amend the Flume as outlined in LU 114 in the comprehensive plan. Further, I request this motion include the summary of evidence and testimony presented in the witness at this public hearing.
Second.
Thank you.
I'm sorry, who was the second?
Mary.
Commissioner Vitale, thank you. Commissioner Volkert,
Yes, ma'am.
Commissioner Warren,
Yes, ma'am.
Commissioner Blackburn,
Yes, ma'am.
Commissioner Clark,
Yes.
Commissioner Graham,
Yes, ma'am.
Commissioner Ritchie,
Yes, ma'am.
Commissioner Starks,
Yes, ma'am.
Commissioner Unseld,
Yes, ma'am.
Commissioner Vitale,
Yes, ma'am.
Chair Runner.
Yes, ma'am, and the motion carried. So now we'll address the zone change request. I'll ask for that motion, please.
Make the motion to approve proposed zoning map amendment together with the condition upon the general development plan document number 2021-32 Z County. Based upon the documents presented in this public hearing, proposed zoning map amendment is consistent with the adopted Focus 23rd comprehensive plan, is demonstrated by its compliance with the objectives and action items presented in the staff report. Further, the proposed zoning map amendment is in agreement with the adopted comprehensive plan. Further request this motion to include a summary of evidence testimony presented by the witness public hearing.
Thank you, sir. We need a second.
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 Thank you.
I'm sorry, I can't see everybody on the screen. Who was the second?
Second, Starks.
Thank you, sir. Commissioner Warren,
Yes, ma'am.
Commissioner Blackburn,
Yes, ma'am.
Commissioner Clark,
Yes.
Commissioner Graham,
Yes, ma'am.
Commissioner Ritchie, Commissioner Ritchie,
Yes, ma'am.
Commissioner Starks,
Yes, ma'am.
Commissioner Unseld,
Yes, ma'am.
Commissioner Vitale,
Yes, ma'am.
Commissioner Volkert,
Yes, ma'am.
Chair Runner.
Yes, ma'am. The motion carried. Our recommendation will be for approval, and we thank you all. Next item, docket number 2021-33 Z County, Gemstone Properties Development LLC and the estate Tony Price have filed an application to rezone tracts of land containing approximately 18.6 acres located at 0, 7134, 7168, and 7208 Russellville Road from agriculture, residential estate, and highway business to general business and planned unit development, both with a general development plan. And we will hear the staff report from Ms. Herb.
Thank you, Chair Runner. We had a pre-application conference on January 20th for the properties outlined in yellow located on Russellville Road. The current zoning of the properties is mixed of ag, RE, and highway business. And the current use of the property is mostly agriculture. And looking at the land use map here, you can see that the surrounding area is mainly agriculture and single family. There are also a handful of commercial and public institutional uses in the vicinity. Rockfield Elementary School is located south of the development on Russellville Road, and there are also several vacant tracts in the area. Future land use designation for the property is mixed use residential, and the general business and PUD zoning districts are listed as potentially compatible in this future land use category. The request that's before you this evening involves two zoning districts. The first, if you look up front, the Russellville Road is to the right here, but you'll see up front there are 4.4 acres roughly proposed to be rezoned to general business, with the remaining portion of the rear, roughly 14 acres, proposed to be rezoned to PUD or planned unit development. And looking at the preliminary development plan here, you'll see that there are some commercial tracts proposed up front, with the balance of the property proposed to be used for single-family residential purposes, including single-family attached development. The development plan also spells out that other uses in the PUD zoned area that would be permitted would include, sorry, I should have had this marked more clearly. Churches and outdoor recreational areas. With that, just looking at the density, we did include a density map in your packet. Let me jump to that really quick, and you will see that densities in the area for both existing subdivisions and approved developments range from 0.19 dwelling units per acre to 15.86 dwelling units per acre. The proposed density for the PUD portion of the development, which would be the residential portion of the development, is 7 dwelling units per acre. Jumping down to signage, go back to the concept plan here. Staff has noted that very little freestanding signage is located in the immediate vicinity of the proposed development. The existing freestanding sign for the Fred Metter Body Shop, which is located next to the property, measures between 11 and 12 feet in height with a total sign face area of approximately 40 square feet. This is much shorter and smaller in square footage than the maximum 20-foot height and 100 square feet of sign face area proposed in the development plan conditions. Looking at proposed open space, just below that, the maximum allowable lot coverage in general business is 80%. So 20% of the general business portion of the development will remain open space. Also, regarding the PUD portion of the request, open space will include a perimeter walking trail. Will also include landscape buffers required by the zoning ordinance and an interior system of sidewalks and open space adjacent to the boulevard entrance. I think that's roughly in this area here on your concept. The maximum lot coverage per lot that's set in the concept plan for PUD portion is 70%. Jumping down to our traffic impact study requirements referenced in 314 of the zoning ordinance. There are exceptions to this requirement if the applicant and affected transportation agencies can agree on the anticipated impact of the development and necessary improvements. And so with that, the Kentucky Transportation Cabinet and Warren County Public Works Department did not require a traffic impact study in lieu of a commitment from the applicants that the improvements listed on page 4 of your report be agreed to. And so those include from Kentucky Transportation Cabinet, a new street to provide access to all properties in the proposed development. And depending on the commercial uses that are ultimately developed, additional improvements may be required. But you will see from your concept plan that there would be one main new street coming into the development to serve all of the properties within the proposed development, and that none of the lots fronting Russellville Road would have direct access on Russellville Road. Number 2, from the Warren County Public Works Department, they requested a dedicated right and left turn lane be provided on the newly proposed street. So that would be as you're exiting the development onto Russellville Road. And access for commercial lots on the new street would be situated as far back from Russellville Road intersection as possible. Again, as you would see on this concept here, you see those new entrances for these commercial out parcels here would be located as far back from Russellville Road as possible. The applicants did agree to these requirements in the development plan conditions. So there are 2 sets of development plan conditions, one for the general business portion and one for the PUD portion. Many of them are the same as far as topics go. So I'm going to read through the ones that are the same for both as far as the development plan condition topics. Number 1 looks at access. 2 outlines building materials and building orientation. 3 requires that utilities be placed underground. I'm going to jump down to 6, which requires uniform lighting. 7 limits the maximum height of any structure to 2 stories in height. And then 9 addresses sinkhole mitigation. Specific only to the general business portion of the development, we're going to look at number 4, which is signage. Again, there's a proposal of a 20-foot height restriction on freestanding signage with a maximum sign face area of 100 square feet per sign face. And all signs within the general business portion of the development would be monument style. Number 5 outlines prohibited uses for the general business portion of the development. And number 8 sets the hours of operation from 5 a.m. to 12 midnight. Then jumping down on page 5, I touched on a lot of these items already, so I'm only going to touch on the ones that are specific to the PUD portion of the development. Number 4 does look at signage for the PUD section being limited to monument style. Freestanding signage no taller than 6 feet in height, limited to 60 square feet of sign face area, and no backlit signs shall be allowed. And number 5 limits the uses in the PUD portion of the development to single-family residential, including attached single-family, churches, and outdoor recreational areas. And then number 9, jumping down to number 9, addresses screening requirements for the southwestern property line and tree preservation. That would be the bottom property line on your screen on the concept here. Looking at the Focus 2030 category review, the staff evaluated 17 items. We found 5 of those items to be in compliance, and 12 of those items the Planning Commission should evaluate for compliance. The first being LU 1.1.3, which looks at compatibility of the proposed development. I'm actually going to read a little bit more on this than I normally would. The Planning Commission should determine if the proposal is compatible with the area, including the proposed signage for the general business portion of the development, and the number of residential units allowed per building in the PUD portion of the development. The most intense residential zone identified in the mixed-use residential future land use category is RM3, and this zone is limited to a maximum of 8 units per building. The applicants have stated that residential uses in the PUD portion of the development will be single-family, but did not limit the number of single-family attached units per building that may be permitted within the development. The Planning Commission should determine if allowing greater than 8 units per building is compatible with the area and if it complies with LU 1.1.3. Next, looking at LU2 and LU 2.1, which look at quality of development and character of the area. Jumping down to LU 214, PR 1.7, NCR 1.1.6, which look at tree preservation. The applicants did agree to preserve a portion of the trees on the property, but did not address all trees located within the development. Jumping down to LU 2.9, that looks at the character of the Rockfield community. Next, HN1 and HN 1.3, which look at suitability of the proposed development, the existing character and pattern of development within the area, and the impact on nearby neighborhoods and districts. Next, HN 2.1 and HN 4, which look at suitability of the proposed housing type and the housing options available in the area. And last, ED1, if the proposal will help to diversify the local economy. That'll jump back to page 1 and wrap up with the points to consider. First, the proposal is generally consistent with the future land use map and mixed use residential category. Proposed development complies with the majority of the site characteristics review criteria and the review criteria for site design, with exceptions noted regarding freestanding signage for the GB portion of the development and the number of attached residential units permitted for the PUD portion of the development. And last, compatibility of the proposed development should be determined by the Planning Commission. That is all for the staff report, but I'm happy to answer any questions.
Thank you, ma'am. Questions from Ms. Hart, commissioners?
So Rachel, I guess it would be best probably to ask the applicant, but if they're planning on putting more than eight buildings attached together.
Yes, sir. The concept does not depict.
Yeah, the concept doesn't look it, but I guess we just need clarification.
Yes, sir.
Okay.
And do we have any idea what the general business areas are going to be?
No, ma'am. Just looking at the concept here, I can zoom into that area. I think they've got some general footprints here, but I don't know if there are any definitive uses planned at this time. Like at least what's shown on the concept would appear to be some sort of fueling facility with a gas canopy out front, and then some other general office or commercial space in these other two lots. But I do believe this may just be a concept, but I'll let them speak more as to whether or not they have a definitive user in mind.
Thank you.
Any other questions before we hear from the applicant?
Rachel, this is Tim Graham. With regard to the residential portion of the PUD, there appears to be no size in the general development plan conditions. Is that an oversight, or did they mean to not have a size restriction here?
Are you asking about the square footage for each unit?
Yes, ma'am. I'm sorry for the poor description.
What would that be?
No, you are correct.
Less than 1,100 square feet per resident.
Let me see here. Forgive me. Is that, it may be in the,
It probably isn't. I don't think it's.
I think we listed the home size for the development across the street, but I do not believe that the applicants have proposed a restriction on the square footage for those residential units. That's a great question, and I do not see where that is listed anywhere in the narrative or the conditions. So that may be a question for the applicants here in just a little bit.
Okay, so we'll address that to the applicant. And then is it also, it's kind of a follow-up on Christian's question earlier. If the zoning is changed, are they required to do these? These are depicted as all single families, it looks like.
Yes, sir. And that, I think in the conditions, it's a little misleading. If you look on page number 16, under the uses in the concept plan, the written concept for the PUD, it does say that the uses would be limited to single family as far as the residential component.
Perfect. All right. Thank you.
Yes, sir.
Any other questions? And then we'll go ahead and hear from the applicant, please.
Thank you, Chair Runner. My name is Kevin Brooks, and I represent the applicant. We don't have really any additional evidence to add to the staff report. I'll try to answer the questions that I've heard from some of the commissioners as I have understood them. Ms. Hurt's answer is correct. We are limited to single family uses back there. We can't We can't do multifamily. We would not exceed 8 units in a building. In fact, we'd be probably far short of that. In terms of the size of the buildings, it's funny that Mr. Graham, that always comes up in residential developments, and it has not come up here. The development immediately across the street, I believe, has a minimum square footage of 1,050. We will certainly be larger than that. I think the smallest unit here would be maybe 1,100 square feet. This is really kind of a unique product for our community, and that is you have these single-family residences, most of them standalone single-family residences, but they're not standing on their own lots. They will be for rent, not for sale.
Okay, so Kevin, would it be okay with you to add 1,100 square feet to the development plan conditions for the residential portion?
Yes, that's fine.
Thank you.
And are
So
going to
Kevin,
have,
so Kevin, all this is staying on one deed.
It is, Mr. Volkert. I mean, to be precise, we have a concept in front of you that would allow separating this out into lots, but it still would not be a lot per house, because I think our minimum lot size is 1 acre. But the street, that's a concern of ours, and the street pushes back into the PUD section so that we could have street frontage and we could sell off a section of this. That's really not the plan, but we could.
Gotcha. Okay.
Now, Kevin, I may need to ask a question then. It was the understanding of staff that even the attached units would be single family and that each unit could be sold and individually and condoed individually. Because if that's not the case, then this would be multifamily as far as having multiple units on the same piece of property that are not actually condoed or owned individually. So no, these will be every one of these structures will be a single family structure. If we need to, so it could be then that the information we have in our narrative that says 1 acre, obviously that doesn't work.
But Kevin, if these are all single family residents, none of them will be attached, will they?
The ones that you see kind of on the top of the exhibit would be townhomes.
Okay.
Relative to the question about 8 in a building, what you see there is actually 4 in a building. Yeah.
Okay. All right.
Yeah.
And are y'all okay limiting it to 4 to a building for the attached?
We are.
Okay.
But I guess my question, so for the townhomes, if those are not actually subdivided individually, and there's 4 units per building, and that and that the building is just one building under common ownership, that would not be a single family use.
Correct.
Structure.
Correct.
That's why I need to ask for this clarification. I'm sorry.
Okay. That's a biggie. Give me a moment.
That'll put us less than our 7.
So we're fine just to eliminate those and do them all standalone single family structures without any townhouses.
So all individual, no multifamily.
Yes.
Okay.
Are we committing to a garage or no garage, attached or unattached?
No garages, no.
And what about materials?
The
They put
materials
it in
are
their
addressed.
60, yeah, they're addressed.
I think we've addressed those.
60% front facade, masonry materials.
Yes.
But are they going to be similar or are they all going to be different? That's what I meant. I'm sorry.
Okay, I'm sorry.
Well, we have not done a DPC on that, but I think would be quite a bit of commonality on these. It's going to be, it won't be multiple builders or anything like that, Ms. Clark.
So Kevin, would y'all commit to maybe a 2-color scheme?
I get a little nervous doing that kind of designing here on the fly in a hearing. Well, let me be sure I understand what you mean, Mr. Volkert.
I think what we're trying to prevent is all of a sudden you got 9 different colors out there and just a bunch of hodgepodge looking things. If it's going to be kind of an all rental, I mean, it's and maybe 2 is not the right number. Maybe it's 4, but I think what we're just trying to prevent is a hodgepodge of a bunch of rental out there of 10 different colors.
Kevin, I'll add just a little bit more history to this. In the past, what we've tried to do is create some uniformity with the multifamily, and this is pretty close to multifamily. Clearly, they're single-family structures, but
yeah. So I don't want to act like I don't understand what you're after. I got it. I got it. So I've been through this one, but we need to talk about it a little bit if we could.
Absolutely.
I'm gonna. So excuse me for taking so long. The plan for this is there are 5 building footprints in that entire development. So I guess what we would like to propose is 5 color schemes at a maximum.
I'm okay with that.
All right.
And we're going to add that to the development plan conditions, correct?
We want to make that a DPC. I assume that's what you're asking. That's.
Yes, sir.
Okay. So go ahead.
Nope, let's take care of this first. Go for it.
I think that would be, where am I?
About at number 2.
Number 2 in this section, yeah. A sentence at the very end of that, Mr. Moore, that says there will be a maximum of 5 color schemes for residential structures?
Is there sidewalks in this?
Oh, yeah. Yes.
There are sidewalks and open space.
Yes.
Graham, Mr. Volkert, you all feel that's adequately addressed?
I think so. I'm good with it.
I'm okay.
I think one last question though, Hamp, do we need to address the change to all single family? We did change those multifamily structures to single family. Is that?
I think so,
is that
Tim,
just
because
apparent?
it says, doesn't it already say that everything is a single family?
Yes, it does actually. So
Yeah, so really, I think it's already taken care of.
right.
Got it.
They'd have to
All
change it. They'd have to change it if they wanted to do the townhomes.
I see. Okay, thank you.
Wait, I'm sorry, and this is probably just very technical here, but I would suggest maybe wording it to single unit residential structures, because I guess as far as the zoning ordinance goes, if you have multiple structures on the same property, the use would be multifamily because there are multiple structures on the same tract of land. That's why I had mentioned earlier that it kind of threw us for a loop, because we were under the impression that each unit could actually be sold individually, meaning single family use. So it may be worth clarifying the intent, being that it would be limited to single unit residential structures and not necessarily single family use, because if there are multiple structures on the same lot, the use would be multifamily.
So we're not looking at the development
That's why-
plan conditions, but rather at the concept plan under Roman numeral #1. And instead of saying single family residential, you say you want it to be single unit.
Yes, sir. I think that would clear things up.
Kevin, you okay with that?
Yeah, we trying to wrap our head around a lot of this. What I think I heard you say is that we just changed the very first item in the narrative concept plan to read single use rather than single family. Is that what we're saying?
Single unit.
Single unit. Yeah, we're fine with that.
While we have the applicant on here, do we have any idea what the buildings up front are going to be at this point?
No, ma'am, we do not. They are in discussion with multiple potential tenants, but no deals yet.
So let me, I'm sorry. If you all, Ms. Clark, did you finish with that topic?
Yes, I'm sorry. I thought you were finished. I'm so sorry.
Well, no, I was, but I've thought of something else. So can we go back to that concept plan amendment under Roman numeral #1? Does it make any sense to say that these are single unit detached residential?
Sure. Yeah, that's fine. That's our intent. Yes.
That'd be appropriate. Mhm.
That's fine.
Family detached. Okay.
Detached.
Correct.
Thank you. I'm sorry.
Any other questions or anything that you need to add, Mr. Brooks?
No, ma'am. Thank you.
Do we have any opposition to this request?
I have a question.
Yeah, yes, ma'am. If you would state your name and address for us, please.
This is Lisa Sample Brown, 829 Old Mount Pleasant School Road, Alvin, Kentucky.
And You swear to tell the truth?
Yes, ma'am.
Thank you. Go ahead and ask your question.
We have adjoining property to this development. I guess the first question I have is, I'm a little confused as to whether you call it a single unit for a family or a single residence for a family. It still seems to be multi-unit rentals that is going in. And I'm a little confused as why it would not have to be rezoned as, you know, multiple residential or multiple like rentals, if it's all going to be rentals. And then the other question I have is what type of barrier, I know I've sat through some of these other discussions and we've talked about fences and trees and shrubbery and, you know, green space between this type of development and the current residential area. Does that go all the way around? Does it just go on one side? You know, where are the barriers between people that are already living there in single structures to what's now going to be a rental complex?
I can try and answer those questions, ma'am. Just to confirm, can you see the screen?
Yes, ma'am.
Okay. Are you the adjacent property owner here?
Yes, ma'am.
Okay, thank you. So to answer your first question about the zoning, our zoning ordinance is broken into several different zoning districts. Some of those include multifamily zoning districts, but the way our ordinance is structured, there is no zone that allows multiple single unit structures on the same property. And so that was why the applicants chose to rezone to what we call a planned development. And so that is the only zone that could accommodate what they're requesting. So I guess, I don't know if that helps answer your question, but the only choice they could have, I guess the only zone they could choose to accommodate what they're proposing, and that there are multiple single unit structures that are detached, would have to be the planned unit development or PUD zone. And then for the buffer question, let me go back to the development plan conditions and read specifically what those buffer requirements include. So if we're looking at the exhibit here, and if I actually, let me go back to the map to where we can see the southwestern property boundary here. It says that and it may be worth the applicants clarifying. I'm not sure if it was their intent to also have this apply to your common property line, but it does say that the southern and southwestern property lines will be screened with a 10-foot vegetative buffer containing plantings as described in the zoning ordinance. Existing mature trees located within 10 feet of the southwestern property line will be preserved during the development process to the greatest extent practical. They have also included in their concept an agreement on landscaping for the perimeter areas that it would comply with the minimum requirements of the zoning ordinance, which would include at minimum a 10-foot landscape buffer between your property and their property along that common property line. With plantings, there are different options you can choose from, and I'd be happy to go through those as far as the numbers if I need to, but there are requirements for buffering in the ordinance.
So it sounds like it's all vegetation and there is no fence of any type.
There's not a fence proposed at this time. The applicants may address that question, but the ordinance would not require a fence.
Is there anything in there that states that it will come past the straight line of Coon Hunters Road and come down to include our property there in that point of the triangle?
I'm sorry, can you repeat your question?
I could have misunderstood, but I thought when we were talking earlier that the 10-foot and what he's proposing as far as vegetation does not specifically state that it also includes our property line? Am I correct in that, or did I misunderstand?
Yeah, we don't want residents to
I
see.
think it may be worth the applicants clarifying the intent of their condition as far as preserving the existing vegetation that may exist within that particular area. Otherwise, if it were not applicable to your property, we do require by ordinance a minimum 10-foot buffer with landscaping.
And just to clarify, it is always been our intention to, for the buffer to go along that little short stretch there. If we haven't worded it properly, I'm sorry, but that's what we intend.
Can we make sure we put some type of wording in there so that's specifically laid out? So it doesn't get overlooked?
Well,
I
think it has to be specifically put in there because it's already part of the requirements.
so that is
true, Rachel?
that is the southwestern property line that we were referring to when we committed to do this. So we thought we had already said it, and you're right, Mr. Volkert, the ordinance requires it anyway.
I guess it is a little strange the way that the direction works out. If you're looking at the map with north being up, which this is not how this concept is depicted, it would almost appear as though that was just a western property line.
Yes.
So I guess it would be worth clarifying that that number, I believe, Kevin, and correct me if I'm wrong, that number 9, development plan condition 9, which includes preserving mature trees that are existing within that 10-foot area, be applicable to the common property line with the Timothy and Lisa Sample Brown property.
Yes, I'm happy to specifically refer to the Brown property line that's being included in that.
Do we have anyone else online with opposition or a question?
I have a question.
Yes, your name, please.
Lizette Garcia.
And your address?
I'm sorry?
Your name and address, please.
Lizette Garcia, and my address is 7142 Stone Mead Lane.
And
Could you spell your name for us, please?
Lizette.
Last name?
Garcia, Garcia.
Thank you, ma'am.
Mm-hmm.
And you swear to tell the truth?
Yes, I do.
Okay, you go ahead and ask your question, please.
So I live right across the street in Weatherstone, and during the big heavy rain, we were completely flooded in, and we could not leave the neighborhood for about 5 days because we only have one entrance that is also the exit. So what I'm wondering is what is going to be done in order to prevent that from happening in this new subdivision, and also what is going to be done to make sure that water that runs off doesn't go across the street into our subdivision, because we obviously cannot afford any more water.
By law, their parcel, they will have to contain all of their own water within their parcel.
So do they have a plan in place?
Kevin,
At this stage, we don't have the, I'm sorry, go ahead.
I was going to see if Thad is on the call from Landmark Engineering.
I'll address that generally. At this stage, we do not require a drainage plan, but we want you to rest assured that the applicant will have to provide a drainage plan, and it will have to be approved prior to moving forward with the project.
So all of that is correct, obviously. I'll just make one other comment, and that is on again, the directions are difficult, but on the top, sort of the northern boundary behind what used to be townhouse units, the original plan had large drainage basins at both ends. There's certainly not an engineered plan yet, but the plan has evolved so that entire area, because there was really no reason not much reason not to just make that entire area able to hold water. So it will, and we think we will really substantially exceed what we have to do when we're finished.
Thank you.
Do we have anyone else with the question or opposition? No one else online. Commissioners, do you all have any other questions or comments? Mr. Brooks, do you have anything else to add before I ask for a motion?
I do not. Thank you.
Thank you, sir. Then I will call for a motion, please.
I make a motion to approve the proposed zoning map amendment together with and conditioned upon the general development plan, docket number 2021-33 Z County. Based upon the testimony and documents presented in this public hearing, the proposed zoning map amendment is consistent with the adopted Focus 2030 comprehensive plan as demonstrated by its compliance with the objectives and action items presented in the staff report. Therefore, the proposed zoning map amendment is in agreement with the adopted comprehensive plan. Further, I request that this motion include the summary of evidence and testimony presented by the witnesses at this public hearing.
Thank you, sir. We need a second. Thank you.
Commissioner Graham,
Yes, ma'am.
Commissioner Ritchie, Commissioner Ritchie.
Can you hear me?
Yes, ma'am, I can now.
Okay, yes, ma'am.
All right, thank you.
Sorry.
That's okay. Commissioner Starks,
Yes, ma'am.
Commissioner Unseld,
Yes, ma'am.
Commissioner Vitale,
Yes, ma'am.
Commissioner Volkert,
Yes, ma'am.
Commissioner Warren,
Ma'am.
Commissioner Blackburn,
Yes, ma'am.
Commissioner Clark,
Yes.
Chair Runner.
Yes, ma'am. The motion carried. Our recommendation will be for approval, and thank you all. The last item tonight.
Thank you.
Thank you. The last item, docket number 2021-34 Z County. David and Terry Perkson have filed an application to rezone a tract of land containing approximately 2.62 acres located at 635 Richpond-Rockfield Rd from agriculture to RE residential estate with a general development plan. And the staff report will be by Mr. Zach Jones.
Yes, ma'am. Thank you very much. All right, we got a pre-app on April 9th for the property outlined in yellow. The current zoning is ag or agriculture. The current land use is single-family residential with mostly agriculture and single-family residential unit or uses in the surrounding area, as well as some commercial and public institutional. And the future land use map is ag. I will note that because the property is non-conforming agricultural parcel that is less than 5 acres and only 1 new lot's being created, no flume amendment was required. The applicants are requesting this zone change today in order to divide the property into 2 single-family residential tracts with a proposed density of 0.76 dwelling units per acre. It has generally adequate facilities and infrastructure available to support the development, with exceptions noted regarding road width. Rockfield Church Road, Rockfield Church Road has 12-foot road width, although Richpond-Rockfield Rd has 17. There are mature trees located on the property and known sinkholes in the area. Going to the site characteristics review, I will note that the existing residence was constructed in 1885. However, it's not a locally designated historic property, nor is it on the National Register. The site design and compatibility review, I'll note the surrounding density that within a quarter mile densities range from 0 to 3.27 dwelling units per acre. And the median density is 0.5 dwelling units with an average density of 0.86 dwelling units. Then a half mile densities range from 0 to 6.51 dwelling units per acre with a median density of 0.58 and an average density of 0.97. That you've got the site characteristics review and the site design and compatibility in your packet. We can go over any of those other items if you wish. There are no specific area-specific policy reviews. In the terms of general development plan conditions, number 1 relates to septic availability and septic systems on the property. The Barren River Health District Department shall perform a site evaluation for any new residents prior to the issuance of a building permit. Condition number 2 deals with access. They will coordinate with KYTC and Warren County Public Works. Condition number 3 is that each new single-family residence shall have at least 1,400 square feet of heated, cooled living space, exclusive of garages, porches. Development condition number 4, each new residence shall be constructed of brick, stone, or concrete-based siding with no exposed smooth-faced plain block above grade. Condition number 5 deals with orientation. Number 6 with existing mature trees on the property. Number 7 with sinkholes. Number 8 with salvageable materials should the existing residential structure at 635 Richpond-Rockfield Rd be demolished or removed. And then in your Focus 2030 category review, we have 19 items, 12 of which are in compliance and 7 of which may be in compliance and are up to the Planning Commission's determination. We'll flip back to page 1 with the points to consider. The proposed development is exempt from the flume and is exempt from the flume in compliance with agriculture future land use category because the property is a non-conforming agricultural parcel that is less than 5 acres in size and only 1 additional single-family residential lot is being created. The proposed development complies with the majority of the review criteria for site design and the majority of the site characteristic review criteria. The proposal meets the minimum requirements in the zoning ordinance, and the Planning Commission should determine if the proposed development is compatible with the area. So all I've got for the staff report, but I will answer any questions, and I believe our applicant is on the line too. I saw him on earlier.
Thank you, sir. Commissioners, do you have any questions for Mr. Jones?
Zach, Tim Graham here. The DPC number 3 addresses 1,400 square feet of heated and cooled space exclusive of garages and porches, but it does not address garages. So you know if is that an oversight or is that something we just need to direct to the applicant?
Commissioner Graham, I actually had some conversations with the applicant regarding that, and it's our understanding, the understanding of staff, that the purpose of this application is to allow the applicants to build a home for a family member, more specifically their mother, and that she would not have a car, is my understanding. He may want to speak more to this, and so I think that might be the reason behind why the home size and garage requirements are proposed as they're written.
I see. Okay, thank you.
Any other questions before we hear from the applicant?
Just wanted to tell Zach that he did a very good job.
Thank you very much.
Outstanding.
No other questions. Is the applicant online? Is there anything that you would like to add?
This is David Perkerson. As far as the garage goes, the house is for my mother. She is disabled, can't drive, so That's the reason that there's no garage being built.
Thank you, sir. Do we have any opposition to this request? Anyone online with a question or opposition? No question, no opposition, then I will ask for a motion, please.
Make a motion to approve the proposed zoning map amendment together with condition upon the general development plan docket number 2021-34Z County. Based upon the testimony and documents presented at this public hearing, the proposed zoning map amendment is consistent with the adopted Focus 2030 comprehensive plan as demonstrated by its compliance with the objectives and action items presented in the staff report. Therefore, the proposed zoning map amendment is in agreement with the adopted comprehensive plan. Further, I request that this motion includes a summary of evidence and testimony presented by the witnesses at this public hearing.
Thank you, sir. We need a second.
Second.
Thank you, sir.
Commissioner Graham,
Made more money this week.
Yes, ma'am.
Commissioner Ritchie,
Yes, ma'am.
Commissioner Starks,
Yes, ma'am.
Commissioner Unseld,
Yes, ma'am.
Commissioner Vitale,
Yes, ma'am.
Commissioner Volker,
Yes, ma'am.
Commissioner Warren,
Yes, ma'am.
Commissioner Blackburn,
Yes, ma'am.
Commissioner Clark,
Yes.
Chair Runner.
Yes, ma'am. The motion carried. Our recommendation will be for approval. I thank you all. That concludes the public hearing. Mr. Peterson, discussion items.
I'll be brief. So hopefully we are in the process of concluding our last Zoom meeting. So our next meeting will be in person back at City Hall, Bowling Green City Hall. And we, I believe we have general agreement to change those starting times to 5:30. So that will be the time that we will start our meetings. So the next one will still be a special call because it'll be at 5:30, and one of our next two meetings, we will make the official vote to change those from 6 o'clock to 5:30 as one of our administrative items. A couple of quick things. Personnel committee met a bit ago. We have some recommendations to forward to all of you. We will do that and take action on those the next meeting. Thought it best to wait for those in person. So that will be at our next meeting. And then on our 17th meeting, June 17th meeting, we'll have additional administrative actions we'll need to take relating to the joint agreement that we expect to be passed certainly by July. And we'll need to kind of get some of that stuff in shape to start in July with our new format. So that's all I've got. I'll be happy to answer any questions, but you will be getting a packet from me probably with your next I guess commission packet that has some of those personnel items in it. And of course, you can always call me at any time with questions, or if we need to have an executive session, since we'll be in person, we'll be able to do that.
Thank you, sir. Anything else, commissioners? Nothing else? Meeting's adjourned, and I thank you all. Thank you.
Thank you.
Night, everybody.
Good night.